John Thompson. Welcome to our call tonight.
Hi, thank you. Thank you. Glad to be here.
So I just want to give you a quick intro. John went to school at Georgetown. He went to work for a big firm. Well, he interned at the Department of Justice, went to work for a big firm for a few years and worked with big companies, and then split off on his own. So John is self-employed. He's one of the managing partners of Thompson and Scrivener in New York City. And who better to tell you about self-employment than John, who's essentially a self-employed lawyer. So John, with that, I want to turn the time over to you, and thank you so much for joining us tonight.
Yeah, well, thank you for having me and for the very kind introduction. I'm excited to be here, and I can say, with my practice, I work with many freelancers, but I also have been a freelancer. Now I have one partner, so I don't know if that has disqualified me, but I still kind of consider myself a freelancer. And yeah, I think it's a great way to do business. So yeah, I'm excited to talk about it. So I have just some notes on a few kind of high-level topics, but I'm also happy to just answer specific questions or whatever I can do. Oh, I think you're on mute, Raymond.
I'm not accustomed to muting myself. I suggest you open up a topic with an idea or two, and then field questions on the topic. So maybe open up something, and then let's ask some questions, and we can go through a few topics that way, and then give time for just any questions at the end.
Sure. Yeah, I think that makes a lot of sense. Well, I'll say the first topic that I think, if you're considering setting up your own freelance business, or if maybe you've just left employment and you're gonna kind of start to try to make it work on your own, the first issue that a lot of freelancers kind of run into or the first question is whether or not to create any kind of an entity, or whether they can just kind of do business as they are. So for most freelancers, this is going to be a choice between a LLC or what's called a sole prop. It's just a fancy way of saying a sole proprietor, which is kind of your default status under the law. So I always use the example of a lemonade stand. If people just go down to the corner and start selling lemonade, technically, in the eyes of the law, they are sole proprietors. It's kind of what you are automatically if you ever do business just on your own. So there are other corporate entities. There's, traditional corporations, and there's a handful of other kind of more exotic ones. But for most freelancers, really the vast majority, the decision will be between an LLC and a sole prop, or just, doing business on their own. So when freelancers are kind of considering whether or not they need this, I usually just, start with the point that the number one reason to get an LLC is for liability protection. So an LLC gives you something sometimes called the corporate shield or the corporate veil, but it basically gives you the opportunity to put a wall up between your finances and those of your business. And what that can really help you if, something goes wrong with the business. Maybe you take on a lot of debt in relation to the business, or maybe you, God forbid, there's some kind of lawsuit and you're facing, losing a bunch of money through the business. You can just then walk away from your LLC, and unless there's some kind of deliberate fraud or something like that involved, generally the law will respect that. You're allowed to just kind of leave it. So that's really, in my opinion, the number one reason to get an LLC if that's what you're going to do. There are some other kind of potential benefits. It certainly helps because it makes you look more established, more professional. It shows your clients that you're devoted enough to this, that that you've bothered to create an LLC. There also can be some tax savings beyond a certain kind of earnings threshold. Yeah, so those are really the big three reasons, but I would say the main reason, the liability shield, is really head and shoulders above the other. There are some drawbacks to having an LLC. The main thing is just the administrative stuff. You have to do some filing, some paperwork. You do an additional tax filing, so you have to keep on top of that. Sometimes it's a different deadline. Like last year, all the deadlines got pushed back because of COVID, but they weren't changed to the same deadline for LLCs. So it's something, you know, you're going to have to manage and keep track of. It can also be kind of expensive in some states. Really, just speaking of California, it's like $800 a year. In most other states, it's significantly cheaper than that. But, you know, I think depending on how much money you're earning, that might really factor into your decision. So before I speak specifically just about this decision in the context of UX researchers, does anyone have any questions?
Jillian says in North Carolina, it costs $125. That's funny. Well, awesome. So any questions about entity? This is a great opportunity.
All right, well, I'll kind of.
I had a quick question, sorry.
Oh, sorry, go ahead.
A minute. No, it's okay. And it's more related to the liability question. Raymond had said a little bit earlier about one liability concern could be non-compete. And I wasn't sure if that was an issue with freelancers or consultants, because especially if you're in an industry, it seems like it would be difficult to get work with other clients if you were locked into like one particular client. Is that more of a full-time employee concern, like non-compete issues? Yeah, and that's actually, that question is a really good segue to sort of the next topic we're going to talk about, which is, you know, the whole issue of contracts. But, you know, non-competes, but if you set up an LLC, you're technically a business, you know, like any other company. And non-competes among businesses are kind of more rare and specific. I mean, when we talk about non-competes, we're probably referring to like what you have to sign as an employee. And that would have to be in your individual capacity. So yeah, it usually, you know, you're not gonna, they're kind of in different worlds, if that makes sense. Okay, yeah, that's kind of what I was thinking. I just wanted to make sure about that.
Yeah, well, that is a good, as I said, it's sort of a good transition to another big topic here, which is the idea of business conflicts. I know that's something that with UX research and specifically can be really a major concern. And that's just the idea is, you know, are you going to get in any kind of trouble because you've worked with company X and then you go work for company Y? The main thing to remember here is that it's all about contracts. You know, there's no real kind of laws about saying, oh, if you work for Pepsi, you can't go work for Coke. In fact, the sort of the policy of courts and the government, they actually want to encourage that. They don't want people to be all tied up by these employment restrictions. That said, a certain amount is allowed in contracts. So if you agree to it in your employment contract, you know, you might be restricted for a period of usually like a year, maybe 2 years, or in extreme cases, 3 years. So when you're kind of thinking about, is this something you need to worry about? The key is just to like know what contracts you need to look at and then really reviewing them on your own. And it's not something you necessarily need a lawyer to help with. You know, you might just have to drink a strong cup of coffee and take out that that employment contract that you signed 2 years ago and really kind of just slog through it and see if there's a provision in there. And there's kind of 4 big clauses that you're going to look for. One is a no conflicts provision. And what that basically just says is, you're not allowed to, while you're working at a particular company, you can't do anything on the side that would conflict with that company. So while you're working for Coke, you can't get a side gig with Pepsi. And the nice thing about that is it ends when you leave your job. So it's not really something you have to worry about once you've left that job. But that's one thing. The other is non-solicitation, which sort of applies to whether you're trying to take clients away from your employer or maybe employees. So solicitation is sort of the idea of, you're leaving and you're saying, hey, come work with me, or let me work for you on my own, or something like that. So those are pretty common, and they kind of work like non-competes. The next one, of course, is non-compete. The non-compete is different than non-solicitation. They're similar, but it just says, you're not going to go work for our competitors. So it's more specific. It doesn't really apply if you're taking away an employee or maybe a coworker you work with. So a non-solicitation is kind of a broader concept. And then the fourth is the non-disclosure, which is just a confidentiality agreement. So those are kind of the four things. And those actually, they seem like they might be totally different, but if you're kind of, let's say you've moved on from a company and you're thinking about doing some work for another company in the same space, you kind of have to think about more than just the do It might be, the non-solicitation. So you're saying, is this company that I'm about to do some work for, were they like, do I know them because of my last job? Maybe they were just a vendor or a subcontractor or a client of your former employer. That's still something you have to sort of figure out whether you're going to breach that. And then the non-disclosure too, that seems like it shouldn't really matter, right? You're just talking about, you're not thinking about disclosing anything in particular, but you do have to ask yourself, with whatever I'm going to do on this new opportunity, am I using anything? Do I have any really particularized knowledge that I have from my past job where I could be in a situation where my former employer is kind of uncomfortable, maybe even accusing you of using stuff that was confidential, that wasn't supposed to be used? That was a lot. I should probably take another break and see if anyone has any questions on that.
Megan, go ahead.
So one of the, I have a couple of questions. Typically, if we're doing research, we often do research for companies across the US. So where if we do an LLC or a corporation, do we have to incorporate where we live?
Yeah, that's a really good question. The short answer is no. No, you can incorporate anywhere. So you can incorporate in Wyoming just because it's cheap. It only costs $50 to set up an LLC in Wyoming. So it's really cheap. So a lot of people do that. The only problem with that is technically you're supposed to register where you're doing business, and that can cost just as much as setting up the LLC in the first place. So that's one reason that I just recommend usually just do it in whatever state you live in. I think that's for most people, that's going to be sort of just the most tried and true way to do this, the easiest way to do it. Now, that said, I think your question too goes to more than that though, right? Like if you're probably asking, oh, well, if I have my LLC in Idaho, but I have a client in Oregon, do I have to register in Oregon? And with that, there's a lot of gray area. Like, to be honest, a lot of this system came about before we had the internet and before it was so easy to cross state lines to do business. So I can't say it's crystal clear that you don't, there aren't really clear rules right now. States do have rules, but you have 50 different states and 50 sets of rules. But generally, if you're doing a really service-based business like UX researching and you're in one state you don't really go to the other state physically, I think you're just fine just registering in the state where you exist. Because it begs the question, who's really going to who? If you're meeting online, so the most important thing is that as long as you're paying some state, as long as you're declaring your income in a state, you're probably going to be okay.
Yeah, it's like I was looking at, I think, LLCs in Silicon Valley, and often you have to register at the county, and sometimes even also the city if you're working out of your home. That gets to be a little fuzzy. And some of the rules, like I was in Mountain View, and some of the rules were so bizarre, like they limited how many deliveries you could get. But these days with Amazon, just being a regular old person exceeds the number of deliveries. And like you can see, it was like some old rules. So you're not setting up, an assembly line in your living room. But
yeah,
I don't know how much flexibility you have about where you register. I had a friend who lived in Mountain View but managed to register in San Jose.
I see.
I mean, how do you make those decisions?
It's tough. I mean, there are a lot of sort of, as you say, more municipal level laws about that are not always well-written laws, and it's hard. I will say this though, if this is a situation where it helps you to not be an LLC, if you set up an LLC, it's way more likely you're going to be treated just like any other company, small or large, and a lot of the rules will apply to you. But if you're a sole proprietor, they tend to get a little bit of a pass on a lot of things that an LLC wouldn't, because it's clear that you're just a person at home earning a living just for you. So yeah, I guess that's something to factor in when you're deciding whether or not to do an LLC or not in the first place.
And then the difference between an LLC and a corp, like one of the things that confused me about that is the corp pays you, but then you pay taxes on the corp and you pay income taxes. So you're effectively getting taxed twice on that same amount.
Yeah. Being a corporation as a freelancer is really not something I'd recommend, but both from a tax perspective, but also corporations have a lot more documents that you're supposed to do. There's a lot more formalities that you need to comply with as a corporation. So I think it's a very, if you're considering creating a business like a startup and you're going to scale it up and hire people and get investors, then I would recommend a corporation. But if you're comfortable just operating as a freelancer, then LLC is definitely the way to go. Yeah. All right. Well, I'll just keep going into our next topic, but if anyone wants to rewind to that, that's totally fine. So the other thing I was going to talk about is collections issues, which doesn't, it's one thing when you're fully employed, that paycheck shows up every week and it doesn't seem like it's just you're able to take it for granted, which is nice. But when you become a freelancer, you really have to put a lot more time into the invoicing and bookkeeping and this kind of thing. So I always like to talk about this because it is incredibly common. No matter who your clients are, you see a lot of people either in bad cases just not getting paid, but more often having to wait a very, very long time to get paid, or having to just kind of follow up a lot to get paid. So, I think as you start your freelance business, you'll start to recognize certain kind of red flags, but I really call them yellow flags, because you don't want to say no to business just because there's something that you might not, you might have doubts about, but you start to recognize signs of a potential customer that might kind of put you on notice that this is some customer or company that you might have trouble getting your invoices paid for. So one thing is, Raymond and I were talking about this, startups is, you know, a term used a lot now. Startup could certainly be a big, very well-funded companies, and it could make a great client for you. But, you know, really early stage startups are eventually going to run out of money. Most of them do. And when they do, they're going to leave a lot of unpaid bills. So that's something to factor in. Certainly overseas companies, if you have a client that is in another country and they don't pay you, you don't really have any recourse, you know, any practical recourse. You're probably not going to go hire a Swiss lawyer to sue someone in Switzerland. It's just not going to be worth it. So that's another thing you have to factor in. And then kind of more specific to your industry, you might learn sort of things that'll put you on notice that it might be harder to get paid. Now, in terms of what you can do to really get ahead of the ball on this and cover yourself, I always recommend just being very professional and organized with your invoicing. A lot of freelancers make the mistake. They're kind of very laid back about it. They focus on the work, which is totally respectable, but it comes at a real cost if they're not sending sort of invoices at clear intervals. That's something that can really cause problems. You know, if you send a client an invoice just once every 3 months, then they might really get sticker shock, and that's going to kind of create a tension. So, you know, you want to pick an interval, either twice monthly or maybe monthly is the most common, or every other monthly. But you pick that interval and then you really want to try and stick to it, and have sort of a system and be very rigorous about it, because the more organized you are, you know, your clients will see that, they'll appreciate it, but they'll also know that, you know, they have to respect your system, and they'll get them to pay. So another thing is, and we'll talk about this a little later, is certain contract terms that you can have in your standard agreement, or that you can kind of bargain for, that can really help you to get paid if you're in a situation where you really need to press someone to pay your invoices. Does anyone have any questions about that topic specifically?
Or for the contracts, do you have a standard or boilerplate contract that you like, or a site or a source?
I guess I would say I don't. Maybe I could talk to Raymond about trying to circulate one. I do have one, or, you know, I have a lot of examples. So yeah, that's a good idea. Maybe we can follow up on that.
And you know, freelancers are on that line of not having very much money, but clearly needing legal advice. So when's the best time to get a lawyer involved?
I think, you know, if you have an invoice that's more than 5,000 or 10,000, it might not be, and you really cannot get paid, and you really just don't think you're going to get paid otherwise, then I think it's worth calling around and trying to find an affordable lawyer, and really emphasis on affordable. But I think, yeah, that makes sense. I mean, if that's what it comes down to, then you don't have any other choice. But yeah, it can still be, you know, it's not like that's necessarily too small for a lawyer to spend some time on.
And I say you don't have to call around. John would be an excellent choice to represent you as a freelancer to, you know, collect from your client.
Well, I appreciate that. Although you know, I think it's important to find someone local, because I'm licensed in New York. I'm not allowed to go suing people in, you know, all 50 states. So in terms of disputes, it's always good to have someone local, because they're going to be able to do it locally.
Well, that brings up a question I've had for a while here. You know, if you're working with someone out of state and there is a dispute, which state takes precedence when it comes to enforcing your contract or your payment clauses and what have you? Are you required, do they have to go by the rules in your state because you're the one that gave them the contract and set up the terms, or do they have to, are you stuck with wherever they're located?
Yeah, that's a great question. That's a great question. And that comes up all the time. And it really is unfortunate because, there's two sides and they want a resolution to their dispute. But before they can even start talking about that, they're fighting about where it's going to be, spending way too much time and money trying to sort that out. So yeah, that's a great question. And the truth is, honestly, if it's not written in your contract, then there's no default rule. So you can get into a situation where neither side really knows for sure what law is going to apply. And a judge is having to do this complicated analysis to decide which state's laws are going to apply. So that's a really bad situation. And for that reason, any good contract, and probably any contract any of your clients give you, is going to designate what law applies. So it's just a really important contract term. And honestly, some people will, do this complicated analysis of which state's law would favor me more. That's kind of hard to figure out. I mean, there's just so many factors, and you don't know when you're drafting the contract what the dispute is even going to be about. I would just say, you just make sure that the contract, everyone agrees that this is the law that applies, and this is where we would resolve any dispute.
Thank you.
Yeah, and that's actually another good sort of segue into kind of the next section I was going to get into, which is, the topic of contracts. If you're a freelancer and you're starting out, you're either going to have to start getting familiar with looking at a lot of contracts from your customers, or they're going to ask you for a contract. They're going to say, where do I sign? So either way, it's something you want to really get comfortable with and be familiar with. I think the best analogy for the importance of this is good fences make good neighbors. It's not just about kind of the worst case scenario. It really is about getting on the same page with your new client. And it's a great way to keep them happy and keep yourself happy. You want to really, a contract forces both sides to get aligned about what is expected and what will be paid for it and when it will be done. And that is sort of a recipe for a good relationship. Whereas, if you're just trying to avoid this boring conversation about what the contract says, oftentimes it will sort of lead to problems down the road because people just can have very different ideas about different things. So that's why you need a contract. Now, for UX researchers, the big question is, do you want hourly or do you want fixed bid? I think those are kind of the most common. I know that having talked to Raymond about this, he really recommends that freelancers start, or freelance UX researchers start hourly, just because it's a lot easier in terms of getting that contract done. It's just a lot simpler. All you have to do is track your time and submit that time, and there's not a lot more to it than that. With a fixed bid contract, you really have to make sure that contract is defining what they call the scope of work, which is, it can be a lot harder than it sounds to really say, this is what I'm going to do. This is how much time I'm going to spend. This is what will be involved. And then sort of maintaining that boundary can be really difficult too. So if you sort of are not as specific as you wanted to be about the scope of work, you might find yourself having to do a lot of work you really didn't intend to do, just because that's the only way to keep your client happy, because they kind of had a more generous interpretation of what the scope of work was. And then in terms of just, aside from defining the rate of pay and the scope of work, there are all kinds of other things you see in a contract. A lot of them are sort of boilerplate things that go into a contract just because they help lawyers and judges figure stuff out. But honestly, they're not mission critical. There are 4 provisions that I always recommend people, freelancers, whoever, get in the contract. One is the venue one you mentioned. So, or it's called venue or choice of law, which is the idea that the contract should just pick a state, and that's the state where we're going to settle any dispute, and that's the law that's going to apply. The second one is a limitation on liability. So this can be really helpful if something really bad happens that you'd never expected to happen, but you're getting accused of sort of losing data, which then sort of cascaded so that something else bad happened and all this bad stuff happened, and it's all attributable to something you did, and you're getting accused of, you're sort of asked to take responsibility for all of that. So the limitation on liability can say that, you know, you're not really responsible for anything more than whatever you've been paid. And that can really, really save you a lot of trouble in a lawsuit if that happens, God forbid. The
John,
other, sorry, go ahead.
so I was gonna say, with that, what does it technically, or what is like the actual outworking of you're not responsible for any more than you've been paid? So say you do lose data on, and you've collected data on, like, I don't know, 15 users or whatever, and you lose all that data, is that basically saying like anything downstream from that you're not responsible for? You're only responsible for the fact that you've lost the 15 users or 15 participants' data, and not the fact, I don't know what, I can't, it's hard for me to kind of envision what could like catastrophically cascade from that. But yeah, how can you talk a bit more about that before you go into the
Yeah,
last?
absolutely. Well, it's, lawyers call it the concept of consequential damages. So it's sort of like, if you hire someone to like park your car, but then they crash the car, they're going to expect to have to pay for the car. But what if you tell them you had a ancient Fabergé egg in the trunk and it smashed? Like, they didn't really expect that there would be it's not really fair to ask them to, so it's kind of that idea. And you can have a provision in a contract that says you're not responsible for consequential damages. But even better than that, you can have one that basically says, look, if you're going to give me $5,000 to do this project, and as something goes really bad, I'll give you all the money back, but that's it. I can't, if you're having me do something that's with extremely sensitive work, I can't be held responsible for millions of dollars, you know?
I have an example that might be helpful. I used to contract with the banks and do user research. And there was a concept of always having to be super careful with the customer's private information, whether it was, you know, their bank account numbers or their passwords or anything like that. So if there was like a breach of security and that information got out in public, if they wanted to attribute it back to me, if I was a freelancer there, I could see where that would be very consequential damages and everything. And I'm not sure, not responsible for more than paid would probably cover it, but I would think that that would be something that would be research related that could wind up being a legal problem. So yeah, there are always really strict laws around that type of information, you know, the customer's private, you know, banking information.
Yeah, absolutely. And that's an excellent example. I mean, the data thing, you could be hacked tomorrow, you know, without having done really anything wrong, but you know, you shouldn't have to. You're doing your business. If there's anything that your clients have that's so secret or important, you know, then they should be taking their own precautions, and they can't ask you to kind of be the underwriter for anything that could go wrong. Yeah. So those are things kind of on the I guess I was going through the 4 contract terms that I think are particularly important. And there's a limitation on liability, the choosing the venue in which law applies. There's 2 more I recommend that are back more on the collection side that will just really help you if you cannot get your client to pay for what you've done, the work you've done. One is an attorney's fees provision. So in the United States, the default rule is everybody pays their own attorney's fees, and it's, you know, it's just not cheap at all. It can totally overshadow whatever the dispute is. Maybe you have an open and shut case for $5,000. If you have to pay to go all the way to trial, it's just not going to be worth it. So having that attorney's fees provision can really change the game, and they're enforceable in all 50 states. So you can put it in your contract and just say, look, if you don't pay me and I have to sue you for it, then I'm going to get attorney's fees. And I could, you know, I kind of wish I brought samples of these. I can maybe follow up or something to provide samples of what these provisions look like. But it basically says if any side sues the other, then the prevailing party gets attorney's fees. Or sometimes it says that, you know, if a contractor has to sue for unpaid invoices, they get attorney's fees. So both of them can be really helpful. Although the first one can kind of work against you if something goes wrong, and you know, there might be a good case against you. It could cut both ways, basically. The other provision, which I think is less commonly talked about, that can really help you get paid, is a provision that says if your client doesn't dispute your invoices within a certain amount of time, then any dispute is waived. Because that is a very common thing. You have, you know, a business is going through a really tough time. They're having a cash flow crisis, as they say. Basically, the business has no money. And then maybe they haven't paid you in several months, and they haven't complained about your invoices, but you just haven't gotten paid. And when you really start to pressure them, or maybe you hire a lawyer, suddenly they start scrutinizing the invoice like crazy and saying, well, what's this and what's that? So that is sadly a very common sort of defense strategy. So this provision in your contract can really, deter that kind of behavior, because basically it says if they didn't bring something up, if they didn't bring some issue up within 14 days, say, then the issues can't be litigated. Basically, it's just so, and that can actually make a difference in the court case. So those are just kind of the 4 things that I'd say, aside from defining the scope of work and the rate of compensation. Those are kind of 4 things that I think are particularly important. There's all kinds of other stuff that is kind of important, but you'd be just as well in a lot of cases if you just had the things we mentioned. You'd be a lot better off than a lot of freelancers who might not even use a contract, which is really common and can end badly. I'll just do one more. I have one more kind of high level topic, but I wanted to check in and see if there were any more questions on that. All right, well, there are just a couple more things that kind of Raymond pointed out to me. I know people are always wondering if they need errors and omissions insurance, or really any other kind of business insurance. I think that if you're a freelancer and you're not doing anything really crazy or earning millions and millions of dollars, I think it's probably not necessary. You know, insurance can always provide a helpful peace of mind, but it can be pretty expensive too, and it's not always as clear cut to make a claim on it. And yeah, I think it's a rare freelancer that will need that kind of insurance. They also usually have very high deductibles. Another question is kind of what are the risks around showing samples of work or having a portfolio that you show, you know, so you're showing your work for other clients or former employers to new clients. I think it's good to be careful about that. In a lot of cases, you might want to kind of de-identify it, or, you know, cross out, cover up, or maybe just you can Control F and change the name, but do what you need to make it anonymous. And also ask yourself if it just by its nature, it's just not something that you can de-identify, that you can make anonymous, in which case you might just have to not include it in your portfolio. But it's pretty commonly done. A lot of people do it. Even lawyers do it. They have briefs that they draft for clients. It's technically confidential, but as long as they've kind of made reasonable precautions to make it so you can't tell, you know, the details, then it should be all right. And this is the last thing actually, but I know data security is on a lot of people's minds. In the US at least, there is actually not really strict laws about data security, data privacy, at least for, you know, most of us. There are for, you know, healthcare related things, medical files, this kind of thing, but just for general information, it's not very strict. So as long as you're kind of exercising reasonable precautions, you're using passwords, maybe antivirus protection, this kind of thing, then you're probably going to be all right from a liability perspective. But of course, I think you have to, as a freelancer and as a professional, you know, in the UX space, you're working with different data. You really have to be cognizant of it. Just kind of talk to the client about it and understand if whether or not it's something that is particularly sensitive to the client. And if it is really sensitive, then it's something that you might want to take extraordinary precautions for, and you might even want to charge your client more. And I think that's always fair as a contractor to factor in kind of that kind of risk. You know, if they're doing something that is going to require you to be more careful, then you should see some benefit from that as well.
Wow, John, such great information.
Yeah.
Such great info. I just want to invite any other questions on any of these topics while we still have John. I want to follow up on one thing, and maybe someone else will come forward, but so your suggestion about when you're, first of all, when you need to go back and review whatever agreements you've signed with your employer and whether they govern whether you can work for a competitor while you're still working for them or after you leave them.
Yeah.
But generally, your advice would be, generally, what would your advice be? If a lot of these people will start freelancing part-time on the side. So they'll have their main employer and they'll be freelancing part-time. I'm guessing they should avoid, if they're working for Pepsi, that they should avoid working for Coke while they're still employed by Pepsi. And seek to go outside of that employer while they're still employed. Would you recommend that? Yeah,
I would. I mean, once you're a independent contractor, you have way more flexibility in that space in terms of technically you're supposed to be able to work for whoever you want. You can work for competitors, you know, honestly, you're just supposed to be sort of on a different plane. So there's nothing wrong with, you know, if you are a truck driver, maybe you drive your truck for Coke and then you drive it for Pepsi. It's totally fine. So in that regard, independent contractors are really, it's fine. But employees, yeah, you have a duty of loyalty, it's called, to your employer, and you have to be a lot more careful about that.
Thank you for clarifying. That's awesome.
Yeah. Sorry, go ahead.
Go ahead.
No, it's I was mostly done.
I was gonna ask about, do you have any sort of, I guess, not cautionary tales or horror stories that doesn't have to do with payment necessarily, but other factors?
Yeah, I mean, I think I certainly do with freelancers. I'm not sure I do in the UX space, but I think I have seen numerous cases where people think kind of their business, their freelance business is not very high risk, or there's not a lot of liability involved, but then something happens that kind of changes that perception a bit. You know, I think there's a lot of things that can go wrong. Like, you know, I've seen cases where people just send the wrong email to, so they send an email to the wrong person, especially when they're dealing with emails like bulk emails where you can reply all and send in just an instant. You can send something out you didn't mean to send to like a ton of people, and maybe it was some kind of client information. The client's not happy about it. So I don't have really specific stories I can tell, but I can say that it's, you know, as when you're an employee, you get more leeway in that regard than you do it as an independent contractor or as a freelancer. And when you start to have your own clients, you're going to want to kind of be a little bit more, I don't want to say paranoid, but like imaginative about what could go wrong and what you have to be careful about, because it can be less forgiving.
Thanks.
Yeah.
John, sorry, I know we're over time, but if Raymond, do we have time for one question?
Please.
I'm curious, you talked a bit about figuring out, like, is the company that you potentially want to do work for, is it a company that you found out about or you learned about through your employer because they were a vendor or a client or whatever? How do you make the justification that, like, okay, well, I don't know, like, how can your former employer prove that you didn't know about that vendor or know about that client before coming to work for them? And then how, I guess, like, conversely, how can you say, well, I could have just stumbled upon them and now I'm doing freelance work for them? Do you understand that kind of like distinction I'm making?
Yeah, absolutely. It's a good question. I mean, I think it's, if you left, maybe you work for a company that does some work for Google, but then you go work for Google, it's going to be hard for your former company to argue because everyone's heard of Google. Yeah, however, let's say you go to work for Google, but you work like with the person that you used to know through, yeah, so it could be the personal relationships that give you away in that case.
Okay.
Yeah.
Thank you.
Yeah.
You're going to have to be careful, Fee.
Yeah. I will say though, even if you look at your contract and you think, oh, I can't do this, you should go talk to a lawyer at that point, because a lot of people, their contract just doesn't even mention it. And in that case, you're totally good to go. But if you read your contract and you say, oh, there's something here that, I don't know, I think this might not be allowed, you should go talk to a lawyer, because there are like, the law is getting more restrictive for companies with non-competes and this kind of thing, especially California, New York. Like in New York, if you're terminated, if you're fired, it doesn't matter what your non-compete says, you are allowed to go work for the competitor because your employer fired you. So the idea is like, well, you don't really have a choice but to look for work elsewhere now. So they can't have their cake and eat it too. They can't fire you and then tell you, yeah. So I guess I wouldn't give up on anything just because you think it's barred by a contract. But you know, if you are pretty confident that there's some sort of potential issue, you might want to talk to a lawyer.
That's great advice. Okay, any final, I mean, I guess maybe that was our last question. We are over time. You've been so generous, John, to spend this time with us and share your expertise. It's been fabulous. Obviously, your experience is just right in the domain that, you know, we're interested in.
Yeah, well, it's been a pleasure, and I've really enjoyed talking to everyone. And yeah, I hope you know, if you do think of anything, feel free to follow up. And Raymond, I hope you share my email and yeah, it's been a pleasure.
No, I totally will. And isn't John the first person you go to review your employment contract and get his opinion on, any limitations? I definitely recommend it. I've really enjoyed working with him over the last year, so I do recommend it. John, thank
All
you
right.
for joining us. Appreciate it so much.
Thank you. Thanks again, everyone.